IP laws is definitely a fun one, and these definitely a big issue when it comes down to especially businesses. With good old Kazaa, Napster, LimeWire, BearShare, a lot of these others, Morpheus. Big problem where people will be downloading, let's say, pirated software, even pirated movies, music onto a corporate environment, and the corporation may be liable for that if they're allowing that to take place.
Or LimeWire is offshore, right?
LimeWire, along with several of the others, are usually Kazaa is offshore, but LimeWire and a few of the others are their own servers. So everybody's their own client-server application. So it's throughout the world. And that's what makes it so hard to block, is because there's nobody that can actually target. And I know the guy that did Kazaa, he set up the original servers and whatnot. I believe he was in Asia Pacific region, and they kept trying to get him, and it wasn't illegal in his country. And basically, it just limits his vacation spots too. But then the same thing with like the piratebay.org is, I believe they're over in Sweden. At least they started in Sweden. It's one of the scenarios to where they allow it, but they're also storing a lot of the content. So if they come over to the States, for example, there might be a good possibility they could get arrested or sued.
The downloads are still going on.
Oh yeah, big time. If you go to any of these P2P applications, Emule, LimeWire, whatnot, do any sort of search, chances are you'll find whatever you're looking for. If it's, let's say, a movie that just came out last week, videos, movies, software, even documentation. There was a government contractor that was doing research, and this hit, I believe it was Slashdot or whatnot, and they ended up finding a couple hundred sensitive documents that were being shared through a P2P application. Basically, we're looking at the P2P, looking for specific keywords, and ended up finding another government contractor individual's computer that they installed this software on, and either A, they shared the entire drive, or B, they dumped all the data into that folder. But regardless, it was content that shouldn't have been on the internet.
But to participate in the LimeWire types, you gotta be
yeah, you have to install it.
You gotta, so you're opening up another port.
Yes.
Yeah, you actually sharing everything if you're not careful.
Yeah, and that's the.
They can browse your computer.
Yeah, like with BearShare had this directory transversal vulnerability. So even if you set it up correctly, you can go into the web interface and then get any file that's on their computer. Look at it, even run certain things like the cmd.exe and just do your dir, so you can start doing browsing and then find out all that information. So yeah, depending on the piece of software, especially if it's vulnerable. And almost every web server that at least I've known of, somewhere in its life cycle, it has been vulnerable to directory transversal, at least at one point. And that's the good old .. // And then there's the dual Unicode, which is instead of .. // it's the .. %255C, because some people would have it for the percentage. They would try to decode that to where whatever was going on the outside would become its real value. And %25 is a percentage. So once they basically decode that part, you still have the %5C, which is going to be your slash. So you can get past some of the blacklist for saying you can't do .. / by doing the %255C. But yeah, definitely a huge problem. Trade secrets, depending on the software that you put on there. I've seen a lot of places, anybody remember the term Juarez? Basically good old pirated software and whatnot. Some people would actually be looking for like print files or print servers, file servers, printers. I've seen some printers with large hard drives that happen to have, let's say, FTP server running on them. And the FTP server had a folder, and anything that was put in the folder would then instantly print on the system. But what the attackers look for is anonymous connection capability or default username and password capability. They log into these things and then make up their own folders and then store a bunch of illegal content on the device. It goes back to copyright. Copyright, these protect original works of authorship, which could be anything from a written word, code, it could be artwork as well. Protects expressions of ideas rather than the ideas themselves. The author, to control basically how the work is distributed, reproduced, and modified. Source code, object code, and microcode are copyrightable. How many people heard the case about 2600? Basically is suing MPAA, or the lawsuit vice versa, to where they printed the DSS code, or that decryption code for the DVDs on a shirt. That took a long time, but basically it finally ended to where they were able to say that it's an expression of art because it's printed on a t-shirt. It's not actually compiled code or a source code. Okay, trademark. This protects word, name, symbol, sound, shape, color, or combination thereof, which is used to identify a product, company, and distinguishes it from others. So you need to know the difference between copyright and then trademark. Okay, patent. This allows the owner to exclude others from practicing invention for a specific period of time. Invention must be novel and non-obvious. What's interesting about trademarks, patents, a lot of people will patent an object and have it in patent pending, because patent pending lasts, let's say, 20 years. And then they just keep changing the patent pending. So what that does is it makes it to where, especially if you're a software company, by the time that 20 years is up, or whatever you've been developing, chances are the technology's changed drastically since the previous one, and then you can just keep your new products in patent pending mode. So it's kind of a loophole, but a lot of people are using it. Software licensing. Basically, this is controlling who can use the product. There are many types. Of course, there's the single and then the multi-user. There's a site license, per server license, per personal computer license, number of users, number of current connections, and floating licenses. So you need to know that there are many different types of licensing out there. And if you do not follow the licensing guidelines, then it could be copyright violations or IP violations. Okay, software piracy. Copying and using the creator's work without compensation or permission. There's a Software Protection Association, SPA. It's many software vendors working together. There's the Business Software Alliance, the BSA. It's an international group based in DC. And Federation Against Software Theft, or FAST. This is an international group based in London. So there's lots of organizations that are specifically looking for anybody who's pushing out pirated software. Not only the distribution, but the usage of it. Again, a lot of times you'll see somebody buys a license to a piece of software, and this same license key can be used on, let's say, 10,000 other systems. Those are things that they're also looking for, not just people that are reproducing or cracking the software. Okay, the DMCA, Digital Millennium Copyright Act. The characteristics is basically it's now illegal to tamper with or break into controls that protect copyrighted material. It's basically even goes down to if it's compiled, it is quote-unquote protected.
So when you're peeling back your sticker on your Xbox like the guy yesterday?
Yeah, they broke DMCA. They actually went into the hex and changed content of the software so it wouldn't be seen as being runnable. So basically they changed country code. That's a protection mechanism. On a technicality, that's probably at least one, if not multiple, breaks of the DMCA. So the other ones, for example, when breaking the Xbox, that's not a huge issue because what you're doing is you have a computer system and you're putting one operating system in place of another operating system. But whenever you're going into the code and then changing the code, altering the code, or cracking the code, or reverse engineering the code, that is bypassing the security because it's compiled, quote unquote. And one of the big security things that they did alter when they copied one game and made basically, they cloned it to another CD. They changed some key features within there. They also changed some key security features within the firmware of the Xbox 360. So it can be done. I wouldn't suggest telling everybody in the world that you did it if you did. Also, Microsoft, they do a lifetime ban. So they check for stuff like that. They have software that goes out and actually interrogates your system. So also read your EULAs because they get a lot more information than most people know. They interrogate your Xbox. They see what's been installed on it, what's on the hard drive, things like that. And then if it looks like potentially illegal, they kill your account. And especially if you try to make it to where it'll run things that it shouldn't run. And it's banned for life policy. Yet, they did get better with it, or the Xbox Live, sorry. So if you are not connected to the internet, then of course it's not calling home. You're not being able to get updates. So they probably wouldn't be able to find out, but it's definitely not something I would suggest. Oh, that's another thing too. We will be covering that in here in a little bit, but ISC squared has some canons of ethics. Memorize those. Since they're ISC squareds, you probably will see at least one question on the test relating to their specific wording. But yes, if you do anything illegal or unethical that does not promote the profession, if it basically is, if you start commenting that information security is lost cause, nobody should ever do it, yet I did get my CISSP, which is kind of hypocritical, because you're pushing for the profession, then that's on a technicality probably against the betterment of society and betterment of the profession. Okay, DMCA, the other issue is only protects itself or items that fall under copyright law. Also, main goal is to prevent reverse engineer attacks. These reverse engineering attacks, basically pushed by, again, Moving Picture Association, RIA, because this one big incident, this kid was able to reverse engineer the encryption algorithm for the VOB files on DVDs. He wanted to be able to watch DVDs on a Linux box because there wasn't known drivers for it, or players or whatnot, or free ones at least. So what he ended up doing, this 14-year-old kid overseas, is he wrote his own. And it was very, very little code. And he ended up getting cease and desist letters. Law enforcement went over, threatened to throw his dad in jail because the kid was too young, things like that. Well, the whole issue is that he was able to reverse engineer and then find out how the algorithm worked, which then basically made their security irrelevant. So the problem is when you get, hate to say it or sound poisoned, but organizations that go on the opposite side of security as well. Like the good old Sony case. Sony made rootkits, which rootkitted many, many people's systems. I think there's like 50 different CDs that they put this rootkit on. The simple fact of putting the CD in there, if you had the auto run or whatnot, it then infected your system. They, of course, don't think that there should be any liability for the organization, even if people are using that code as a malicious rootkit. But they did say, well, we'll switch it out for one that has not been rootkitted. And that was one where there was no permission or anything like that to install. So there is a very tight balance between, like the DMCA is that you're not supposed to reverse engineer to find things. The problem is a lot of security researchers, that's the only way they can find buffer overflows and other types of vulnerabilities, is to take a piece or apart the piece of software, reverse engineer it, then find out why it's breaking in a specific area. So there are legitimate reasons for reverse engineering, but a lot of people are no longer doing it. And then it also comes down to the responsible disclosure versus full disclosure. Because of this, a lot of people are no longer doing responsible disclosure because they're afraid the vendor is going to sue them, and they're going to have to spend the rest of their lives and livelihood spent defending themselves. So what they're doing is just releasing all the exploit code vulnerabilities right to the public directly. So again, there's backlash on both sides for this. The controversy today is because some carry out reverse engineering tasks as a white hat and could be prosecuted. It's making a lot of the white hats either gray hats, black hats, or the people that find the information just don't tell the vendor, they don't tell anybody, which means that somebody else probably found the same thing. When things are released to the public, chances are the person that found it, they may not have been the first to find it. They're just the first to tell everybody about it. Okay, first attempt to use this law was against a presenter at DEF CON. Specifically, there was another individual at DEF CON, good old Cisco. He was able to, basically he reversed engineered the iOS, found a vulnerability in it. The whole story you can definitely find online, but there was a break in communications between the parent or Cisco and his organization and himself trying to get the information back and forth, where it ended up being, they said that they were going to be speaking at Black Hat DEF CON. Well, the communication broke again. They didn't say no, So the organization started the presentation. They were there. Then in the morning, a bunch of lawyers came in and basically started ripping all the content that was Cisco related out of the presentation material, and sent a cease and desist letter. After that, what ended up being the issue, the presenter did the presentation anyway, got in a bunch of trouble, but then a couple weeks later was hired by Juniper. So, yeah. Lots of large organizations are pushing the DMCA, and for some aspects, it is definitely nice to have there, but without a medium, people are going extremes on both sides. But definitely know what that is, DMCA. Okay, agenda, complications of investigation, prosecution. There's computer crimes. There's investigation steps and forensics. There's types of evidence. Of course, evidence handling. Evidence handling is a huge issue. Okay, computer crimes and its barriers. It is difficult to investigate and prosecute on almost any computer crime for multiple reasons. Okay, law enforcement agencies, jurisdiction issues. Crime took place in a different area. If it was carried out in China, a lot of times the jurisdiction, of course, is going to be in China. Law enforcement agencies are behind in manpower and skill. There's a lot of smaller rural areas have it to where the law enforcement either do not have the proper training or budget to put their people through training. Current laws may not apply to new computer crimes. Again, with some of the older ones, and why some of the computer crimes actually came into place were because people did things that were illegal or that may not have been illegal at the time but should have been. There's lack of reporting to crime organizations. There's evidence that is intangible and hard to collect. And explaining complex technical concepts to a jury and judge is a huge issue. Because if you can be the best investigator in the world, but if you can't talk down to the jury or down to the level of the judge where they can understand it, then it's going to go way over their head. They're not going to understand why it's a problem. Bless you. And then evidence can get thrown out, or the whole testimony can basically just be wiped out. Also, identifying lawyers that specialize in this type of law is very hard to find. Okay, countries working together. This is definitely a huge problem because with so many countries in the world, a lot of the attackers are finding countries that are like non-extradition or unfriendly to the country that they're going to be attacking, or the country that houses the organization that they're going to be attacking. Many countries do not view computer crimes the same. There are some countries that it may be illegal to do hacking, but it's not looked down upon as long as the hacking is outside the country. There's also state-sponsored attacks. There's each country treats computer crimes differently. Evidence rules differ between legal systems, jurisdiction issues, and governments may not assist each other in international cases. Okay, G8. G8 is a group that represents the world's leading industrialized countries. They have agreed to cooperate in cybercrime. There's International Police Organization, Interpol, collects and distributes information, cross-border crimes. Okay, ensure that a crime has indeed been committed. It's a huge problem, is that a lot of times if the crime has been committed, it should have also violated security policy. But some organizations have it to where if there's a reasonable expectation of privacy, you might not be able to go in and look at everybody's email to see if embezzlement has actually occurred without some sort of search warrant or authorization. Here's a violation analysis. When something suspicious takes place, ensure that it is not a user error or misconfiguration. When one of the individuals should be responsible for investigating and make sure that there's an actual crime that has taken place. This is from a legal aspect. You can also do it from security policy violations. As long as you can ensure that a violation has taken place, then the investigation can commence. Once this is confirmed, investigate the crime and gather evidence. And management must decide on how to handle the computer management or computer evidence, conduct internal investigation, or bring in law enforcement. Every case, policy violation or criminal, should be treated the same because there's always the possibility. If it's just your basic policy violation, it could easily turn criminal. Say, for example, you bring in the evidence and it's somebody's going to inappropriate websites or they're harassing somebody. If you look at that disk and it has CPKP on it, instantly law enforcement is going to have to be involved. Or if it's zero tolerance policy, where people are going to inappropriate sites, they get fired. They may come back at a later date, let's say 1 or 2 years later, and say they were wrongfully discharged or they were discriminated against or some sort of harassment. The problem with that is that if the organization doesn't treat that crime the same as, or the security policy violation the same as a crime, then the evidence may be tainted, thrown out, and the organization or company will lose the case, or more than likely will lose the case. So all cases should be treated the same. Okay, citizen versus law enforcement investigations. Law enforcement, you have to have search and seizure. You have to have probable cause, because if you don't, you have to deal with Fourth Amendment rights and violations. Search warrant is required because of the Fourth Amendment. You will need to know the Patriot Act when it comes down to the test as well. It may or may not be on the test, but how many people here know what that is? Basically, it's a law that came into effect where if there's potential terrorism, then what it comes down to it is the search warrant is basically there's different criteria to get a search warrant under the Patriot Act than there is a normal crime. Okay, citizen investigation. Private citizens is not subject to protection under the Fourth Amendment rights and other rules unless acting as a police agent. Does anybody know when that would actually occur? When would the individual be acting as a police agent?
Undercover. I mean, maybe if, they have somebody who's already part of that organization, they're a mole, and now they're working.
Yep. Basically undercover, same type of scenario as if a law enforcement individual comes up to you and then asks you if you'll do something. If you do it, now you're acting as an agent of law enforcement. So technically that's not a thing that you can do if they ask you unless you have like search warrants saying that yes, you're supposed to. For example, like with CLIA, you have to do any sort of wiretapping or whatnot. It can get really tricky. But yeah, definitely you become an agent of law enforcement if you go above and beyond the rights and responsibilities and roles that you normally would have.
I mean, that's one of the great things about hiring, private investigative firms is that they can do whatever the hell they want, basically, and not run afoul of the Constitution.
Yes.
So.
And that's the danger. Not only PIs, but you have your good old bounty hunters that also have more lenient rules and regulations than a basic law enforcement individual would have. So you'd have the third parties hire those guys, and then they could do things that, for example, like break into a house, which may be trespassing or whatnot, but any evidence which is found during the commission of the crime. Yep.
You can't do a citizen search when you do a citizen arrest?
Yeah, beat them up, steal their wallet. Say, we found the evidence. No, you hire a third party to do that so it doesn't get tied back to you.
Generally speaking, what can a private investigator do that law enforcement cannot do?
For example, illegal search and seizure. So they may get dinged for trespassing, but they...
Like a private investigator could go into your house, and yes, it's trespassing, but if they find anything that might, show that you're guilty, they could still use that in a court of law. Like your defense attorney might be able to throw that out saying, well, it was, an unreasonable search and seizure.
Illegally seized.
Under the fourth, but because it was taken from a private investigator, it's good enough to be admissible in court.
So if the guy breaks into your house and removes that evidence, isn't that theft?
It's theft, yeah.
Yeah.
It still be used as evidence.
But they
Yeah.
could also turn around and say that they put it there.
They could.
Well, I mean, I don't, you have
So
to have
there's
evidence.
weaknesses in that argument, yeah. But
The case, everything's based on the facts, but it would be admissible in court.
Yeah.
Even though, like, if a cop did it, a judge would automatically throw it out, saying, no, there wasn't a search warrant, it's out. But if a private investigator does it, it could still be admissible.
and then it goes down to the sophistication of the person that the private investigator is attacking, because then they could go around and then make it actually look like the PI did the planting of the evidence and all that fun stuff. So it's a dangerous game to play, but it happens. And then a lot of the things is that the PIs don't get in trouble for it, because even though they may have stolen items, trespassing, if the guy was guilty of a big crime, then it's pretty much just looked at as an OL situation. The guy got what they deserved. So depending on the jurisdiction. Okay, roles of evidence in a trial. You have evidence. This is material offered to the court and jury to prove truth or falsity of an act. Used to prove directly or indirectly that an individual may be responsible for committing a crime or could be innocent. Challenge obtaining computer crimes is that evidence is intangible. Electronic voltages are held in a binary representation. They're hard to properly collect and maintain. And it is hard to prove that the intangible evidence has not been modified or basically tampered with by an unauthorized user or in an unauthorized manner. There's the trick is whenever you do your basically tagging bags, you actually have the person that's specialized in grabbing the stuff, which is the best case scenario. You know that the chain of custody has been intact because things have been filmed, pictured, things like that. So there's tape, there's signatures. It gets from point A to point B, and then instantly an MD5 hash is taken. When the MD5 hash is taken, you can do the investigation on the copy. You never want to do it on the original unless there's absolutely no choice, which basically means that you cannot get a copy of it because it's a system that's currently running. It can't go down or it's failing at that time. So once you have that copy and you do all your investigation, when you're done, the MD5 should match. If it doesn't, then basically do the investigation again on a secondary copy, and hopefully you won't change the content again. But there are some cases to where the original does not have to be used. Most scenarios, if the original is available, or in all scenarios where the original is physically there or physically available, you cannot use the copy as true evidence. You have to have the original. But if the original is not available, such as, let's say, if there was a flood, or if somebody basically got their computer, threw it in a pool, and tried to, or in the lake or river or whatnot, and they tried to get rid of the evidence that way, if you're able to get data off that device, the drive is probably going to rust, and it's not going to be available for people to get data off in the future. But if you're able to get the data off while or right after the drive has been recovered, then that copy is next best evidence. Okay, evidence must be material, must be relevant to the case, must be competent. Proper process in collecting the evidence was used. It was obtained legally. Chain of custody was properly followed. And again, it has to be relevant, provide information pertaining to the suspect's motives. Evidence should prove or disprove facts in the case. Chain of custody is probably the most important document in a forensic investigation or incident response. Basically, it has who obtained the evidence and how, where and when it was obtained, who secured the evidence, who had control or possession of the evidence, who was or how was it moved from one place to another, and separation of duties is good control to ensure proper chain of custody. Like I mentioned before, the person that does the tagging bag gets it, transports it, and then the person that does the investigation should be different individuals. The issue here as far as the transportation, if you have it in your car, let's say in your trunk of your car, and you're going from point A to point B from the crime scene to the evidence locker, it is not a good idea to stop off at your local restaurant and then eat for an hour and a half, leaving the evidence in your vehicle. That could easily be a breach in chain of custody because you do not have that item in your possession while you're inside the building. Somebody else could have gone in there, switched the device, things like that. Okay, the types of evidence. You have your best evidence, secondary, and direct evidence. Best evidence is primary evidence, most reliable, original documents, not copies, and not oral evidence. Secondary is not as reliable as best, be copies, oral evidence, or eyewitness testimony. And direct can prove fact by itself, does not need corroborative information. Basically information for witnesses, usually oral testimony. One of the things that you'll come across is, like with computer evidence, if they use it wasn't me defense. If you do not have a very specific proof that that person was the only person that could have done it, then it's a big issue. You now have to have other evidence to basically prove that the person had the means, motive, and operandi. There's conclusive evidence. It's irrefutable and cannot be contradicted. And with computer evidence, that's not going to be the case because anything can be altered, tampered with, depending on the sophistication of the attacker or the perpetrator. Again, like a lot of people will backdoor their systems and say that I wasn't doing all these transmissions, I didn't do anything bad, it was malware that was on my system. So then it's the responsibility of the prosecution to go and say that, yes, you did do bad things, yes, you were infected, but there's no way this Trojan could have done that because it doesn't have the rights on the operating system to do file transfers or copying from one folder to the other, or you had a firewall that was blocking all traffic going out and coming in, so there's no way that anybody could go through that pinhole or whatnot. There's also the issue with computer systems with multiple users. If there's a house that has 15 people in it, or lots of people going in and out of this geographic area, has a bunch of users, or if it has a bunch of users, it's a little bit easier. But if it has only one user, such as owner or the administrator, everybody logs into it, somebody can say it wasn't me, then you have to prove that it was them. And the more people that have access to it, the harder that's going to be to prove. And some people can do it through either eyewitness testimony, or the other evidence could even be like a CCTV. CACs are definitely a fun one to use, because it is something you have, it is something you know type scenario. If you lose the CAC or lose your security card, if you don't tell the registration authority that the certificate that you have is invalid now, that it's been stolen or lost, it is still your responsibility, because that's just the way it's set up. So that's another, basically, a method that you can use as evidence. There's circumstantial evidence, used to assume the existence of another fact. This cannot be used alone to directly prove a fact. And corroborative evidence is supporting evidence to prove a fact or point. Supplementary tool. There's opinion evidence. Witness testifies and gives opinion. Expert witnesses give educated opinions. Depending on the state that you live in, some of them make it to where if you are giving expert witness testimony, you have to be either a licensed professional, or if you're in a profession without a license, have a PI license. Hearsay evidence. No first-hand proof of reliability or accuracy. Computer-generated evidence. And he said, she said. And then real evidence, also known as associative or physical evidence, tangible objects. And this right here, the computer-generated, like the copy of the original is going to be hearsay. But if the original is not available, it's then going to be like best evidence. Okay, there's documentary evidence. Business records, manuals, printouts. Most evidence submitted is documentary. And also demonstrative evidence. Aid the jury in their understanding of a concept. Some people have, for example, a copy of the evidence. Let's say they do a bitstream copy or DD copy or even a drive copy or whatnot. They will use programs like VMware or virtual machines to boot up the system in their virtual environment. Excuse me. And some people even have it to where, let's say the potential attacker had a background of a nuclear explosion going off or some other things that could tend to sway the jury's opinion one way or another. So they may turn on the system and say, look at all these icons that are on his desktop. This guy was obviously up to no good. So, but people are using not just your good old pie charts or PowerPoints, but sometimes booting up the system in a virtual environment. Okay, hearsay rule. Business records, exemption to the hearsay rule. Business documentation can be admissible if it is created during regular business activity. Basically meaning like records for backups. Excuse me. Let's say if somebody hacks a website. The website is generating backups. Excuse me. Excuse me. Okay, the hearsay rule. Business records exemption to the hearsay rule is basically, say if a website's being hacked into, if they don't do current backups of the web logs, they cannot produce those logs and say that these are the evidence that my system was hacked into. It's something that you have to log as a normal portion of business and also store as a normal portion of business, or else it does not follow this exemption. Okay, in this area we're going to cover incident response, forensics, liability issues pertaining to computer crimes, and sets of ethics. And the ethics would be one that you definitely have to memorize and follow, or else risk losing lots of things. Okay, preparation of a crime before it happens. When to develop an incident response team. Some people call them the CIRTs. They used to be called CERTs, but my understanding is Carnegie Mellon basically copyrighted the name and then grandfathered specific organizations to be able to use CERT. So definitely watch out how you name it and then validate if you do have the rights to name it. Okay, there's policies and procedures need to be developed for incident response. Why would that be? Why would you need policies and procedures in case potential? Yep, preserve evidence is one of the biggest things. And you always want to be consistent in what you do, because if you treat different cases differently, even though there's a certain extent to that, if you go after an individual a little bit more fervently than anybody else, it can be seen as harassment, and then you could also lose the case in that aspect. Okay, decide whether an internal response team will be developed, why you would need it, and how big it should be. If the company will use an internal team, the team should be composed of representatives from IT, management, of course HR, legal, PR, public relations, and so forth. And why would you want human resources there?
Checks and balances.
Yep. Checks and balances, and also to fire people whenever they do bad things. So it's the primary thing is make sure that you're doing what you're supposed to do, and it also protects the company if there is a security breach or security policy violation, that the threat can be mitigated. Okay, first goal of incident handling: containing and repairing damage from the incident, preventing further damage, and then after the team is ensured that the spread of the damage is contained, evidence gathering can start. With that being said, as mentioned before, let's say a workstation is compromised. Sometimes you just may take the system completely offline, and that's when the investigation can start. But if it's more important that that system be up and running, you may take that system offline and then replace the hard drive, rebuild it, basically make it to where any backups for it reset. So that is going to take time. There will be downtime, but a lot of times the evidence gathering has to start immediately after the attack has been stopped. Okay, collecting evidence. If you have the capability, photograph the area, what was on the screen, things like that. I know a lot of areas do not allow cameras into it. So what you may have to do also is sketch. That's definitely acceptable. A lot of people will take pictures and then also sketch. For example, the room, what was in the room, how they saw the room. But if you do take digital images, take too many. Because when it comes down to it, if you take, let's say, 500 pictures of a room like this, you can get rid of, or you can only use, let's say, 5 or 6 and get everything you need. But there's always the possibility that one of those 500 may contain something that you missed when you were on site. And if you take too many, if you take too little, that's also going to potentially be an issue. You always want to do a 360 to make sure that every angle is seen. Then also back to the good old evidence collection of disks. The good old USB, a lot of times, especially the tag and baggers, will miss the micros. I've seen USB hidden in poker chips. I've seen them in those good old squeeze toys, those like ducks, those rubber ducks. I've seen them in a Swiss Army knife. I've seen them in pens. I've even used them in pens before. Lots of times people will miss those, especially if they're not specifically trained or if they're not propeller heads themselves. That's the kind of evidence that will be missed more than likely. Also issues, how many people here have had to deal with wireless in an investigation? There was a case where I live. Basically what ended up happening, a guy was dealing with CPKP, and those are usually the ones that stick out the most in memory. But what ended up happening was he had this wireless device, and he had a hard drive on this wireless device. And then he stored this, basically it was a wireless hard drive type scenario, up in an attic. They confiscated all the computers. They couldn't find any evidence whatsoever. Luckily, though, they were able to come back to the environment, and then they found the wireless device by doing an actual scan. And when it came down to it, that was one of the few times that they were able to go back to the scene and gather evidence and it still be valid. The majority of the time, what's going to happen is once you go to the scene, you grab the evidence, it's a first come, first serve, it's a one-shot wonder. So after you leave, chances are anything you miss is going to be destroyed or is gone. Okay, whenever it's a Windows system, Windows Workstation, you want to pull the plug instead of allowing a graceful shutdown. Mainly you're hoping that the memory is going to be, for example, in the page file.sys or whatnot, and it's going to be on the drive, so you can recover at least segments or fragments back from it. If it's a server, especially in a business environment, That is not something you probably want to do, because especially if it has like a database backend in it, you've probably just destroyed the database, and you're doing more harm than good. Okay, photograph the inside of the system and label each piece of evidence. There's been a lot of cases where I've seen even the simple things to where you're labeling what USB ports were connected to what devices on the system. Okay, computer forensics, specialized skills. You need a study of computer technology and how it relates to law. First step is to image the disk. You want a bitstream copy, if at all possible. This means an identical copy of the disk. If you're doing just a basic backup, that's not going to get a bitstream, so you're going to be missing all of the deleted files, everything in slack space. So, for example, if you're using Ghost, the newer versions of Ghost do not do a bitstream image. They just grab what's physically there on the disk as far as the files are concerned, but they're missing the deleted files. So they're not getting everything. So you can use programs like DD, which is a common one used on Linux, and the DCF-LDD, which is the DoD variant of that same program.
What are Windows? Base Windows?
FTK Imager. It's a free one from Access Data. It makes FTK and DD images. There's also the Encase Imager. That's from Guidance Software, and that basically makes it to where you can do DD and you can also do Encase proprietary images. Okay, computer forensics. A few things should be analyzed. Hidden files. There's many ways to hide files. The easiest is just the attribute -H. There's streams, alternate data streams. It's a beautiful thing with Windows NT, which basically had backwards compatibility with some of the Mac files for metafiles, which basically allows you to add data to a file. The operating system in Windows does not see this extra data. So what basically happens, you can have a text file that's a 1-byte text file, then you can have a data stream, or up to literally hundreds of thousands of data streams that could be, let's say, 1 gig, 2 gig, or so forth. So you can hide a lot of data within alternate data streams, and the forensics utilities will see the data because it's going to be on the hard drive, but the operating system doesn't see it. So a lot of malware is actually using alternate data streams, putting in the code in there, and the antivirus isn't even looking. You have slack space. Slack space is going to be the portions on the hard drive, because the hard drive, let's say on a Windows box, you're looking at, there's 512 bytes per sector. And within each sector, there may, let's say, be 32 sectors per cluster. From the operating system standpoint, the smallest writable unit is going to be a cluster. And then the smallest writable unit for the hard drive below the operating system is going to be the sector. So if you have a file that's a 1-byte file, it's going to take up the, say, 32 clusters or 64 clusters, which is a huge chunk of disk space. If you delete a file, and basically it makes it where it's unallocated space, and then you put that 1 byte, it's going to take up basically only one sector within those 32 clusters. So now you have up to 31 clusters that contain data from the previous file. Then you also have the malware, deleted files. When you delete a file, it's still going to be there. There's still going to be a record within the FAT table or with whatever file system. And the beautiful part about most deleted files is the only thing that really gets changed is going to be the first character within the name. It's basically going to become a Sigma character. You can also extract data from the swap file in the Windows system, and that goes back to why you'd want to unplug the actual computer itself. Enticement, and then your entrapment. So as mentioned before with honeypots, is the enticement is basically having something available and having it to where people actually try to break into it, like a honeypot. There's also an issue to where some people have a car, and they'll put, for example, keys in the car, and law enforcement will watch the car looking for somebody to actually break into the vehicle and then steal the vehicle. However, depending on the state, I know in Colorado, if you leave your keys in your car and it gets stolen, it's the responsibility of the owner of the vehicle. But in a lot of other states, it is not that way. Entrapment. This is an illegal attempt to trick a person into committing a crime, which basically means that you go up to somebody and say, I will give you $10,000 to shoot this person in the foot or hack into the system. If the law enforcement agent is giving the opportunity to somebody who may or may not have done it initially, then that is going to be entrapment, and that is illegal. Okay, companies can be found liable. Companies can be found negligent if it doesn't practice their due care. And if they practice their due care and they don't practice their due diligence, it's still going to be percentage-wise. So they may still have all their security policies in place, saying unacceptable use, people aren't allowed to have Kazaa or have any of these P2P applications. But if it's found that during the process they're able to find that individuals have either compromised the network because they downloaded backdoored or Trojanized piece of software, or they're using pirated software, if the company isn't scanning for that or making sure everybody has understand and read the policies and procedures, they may be having an issue. Follow the prudent person rule. Perform duties that a reasonable person would exercise in a similar circumstance. And also practice due care for downstream liabilities, actions or lack of actions that negatively affect another company or partner. The downstream liability is definitely a potential problem, especially in the future, where a lot of organizations, they get hit. Let's say there's $10,000 or $10 million in damage. If they go after the person that attacked him, which could be the good old 14-year-old in somebody's basement doing a script kiddie attack, what's going to end up happening is that if they compromise, let's say, 20 other networks or 20 other systems, and then use those systems to take down a primary, that primary is not going to be able to get to their $10 million from the 14-year-old. So they're going to go after the 20 systems, or the owner of the 20 systems that attacked him initially. And then it goes back down to due care and due diligence. If they don't have the basic security policies in place, or they don't follow the prudent person rule, they may be held liable for the rest of the damages because they allowed it to happen. Okay, set of ethics. ISC Squared set of ethics, Computer Ethics Institute, and then also Internet Activities Board. Memorize. 4 main canons: protect society, the Commonwealth, and the infrastructure. 2, act honorably, honestly, justly, responsibly, and legally. 3, provide diligent and competent services to principals. And 4, advance and protect the profession. And basically they are in that order. So if you're just trying to advance and protect the profession, if that's in violation of protecting society, the Commonwealth, and the infrastructure, there shouldn't be a scenario where that would probably happen, but if it does, it basically goes in this order. Protect the world first, and then your job next. Okay, Computer Ethics Institute. This institute is a nonprofit organization that attempts to stimulate awareness of the ethical issues pertaining to technology. Tries to help to balance citizens' civil liberties and the government's need to monitor individuals. And then provides advisory and consultative activities, research and education, to public outreach. Okay, the Internet Advisory Board, the IAB, is a coordinating committee for the Internet design, engineering, and management. 2 principal subsidiary task force was the Internet Engineering Task Force, or the EITF, and the IRTF, the Internet Research Task Force. Basically, their principle is Internet use is seen as a privilege and should be treated as such. It's not a right. Internet Advisory Board, the IAB, deems the following unethical: purposefully seeking to gain unauthorized access to an Internet resource, disrupting the intended Internet usage or use of the Internet, wasting resources, people, capacity, and computers through purposeful actions, which could go back to potential regular mismanagement issues, destroying the integrity of a computer-based information, compromising the privacy of others, and involve negligence in the conduct of Internet-wide experiments, which basically means that if, for example, if you're doing a full-blown vulnerability assessment on every IP address on the Internet and it starts to crash items left and right, then that's definitely unethical because you are now causing that problem.